Landowners tend to want to use their land how they want. However, zoning is used to restrict the types of uses in a particular area. This prevents things like a factory from being built in a residential neighborhood. In Chrismon versus Guilford County, we'll explore when exceptions or changes to the designated zones can be granted. Bruce Clapp sold grain, pesticides, lime, and fertilizer on his property in Guilford County. The surrounding property was used for farming. In 1964, Guilford County enacted a zoning ordinance that zoned Clapp's and the surrounding property for agricultural use. Although selling grain complied with the zoning requirements, selling pesticides, lime, or fertilizer would not. However, because Clapp used the land to sell pesticides, lime, and fertilizer before the ordinance passed, those uses were also permitted as nonconforming preexisting uses, as long as they weren't expanded. In 1969, the property adjacent to some of Clapp's land was purchased by William and Evelyn Chrismon and used as residential property. In 1980, Clapp moved a portion of his agricultural chemical operation to the property next to the Chrismons. In response to the increased noise, dust, and traffic, the Chrismons filed a complaint with the Guilford County Inspections Department. The department subsequently notified Clapp that he had impermissibly expanded the nonconforming use, but could request that the property be rezoned. So Clapp applied to have his property rezoned as a conditional use industrial district and for a conditional use permit. The rezoning was approved by the Guilford County Planning Board after a vote. After a public hearing where the public expressed the benefits of and their support for the agricultural operation, the Commission also voted to approve the conditional use permit. Chrismon sued Guilford County in a North Carolina trial court, claiming that the zoning amendment and conditional use permit were invalid because they resulted from spot or contract zoning. The trial court found that no contract zoning occurred and found for the county. Chrismon appealed to the North Carolina Court of Appeals, which reversed. Guilford County appealed to the North Carolina Supreme Court.